So, good afternoon and good morning, and thank you for joining us today to discuss the outcome of the long-awaited court decision on the litigation challenge to 13f-2 and the Securities Lending Rule. We've got quite a lot to get through in a short time today, and so I won't do lengthy introductions, as I'm sure actually most of our audience has probably already tuned in to our earlier webinar in January and then our expert talk that we've done on 13f-2. Just to say, I'm Fiona O'Shea, a senior shareholding disclosure lawyer here at aosphere, and I'm joined today by our outside US counsel, Wallace, who's at Sidley Austin in Washington, and an expert in financial services regulatory law. Thank you for joining me today, Wallace.
My pleasure. Good morning, Fiona.
Couple of housekeeping points first. This webinar is being recorded, and we will circulate details of how to access the recording at the end to all attendees. Please can I also encourage you to use the Q&A function to submit any questions that you have, and I will aim to put those to Wallace towards the end of the webinar, and if we actually run out of time, we'll hope to follow up with you afterwards. So let's get started. So last week, at last, the US Court of Appeals of the Fifth Circuit issued its opinion in the case that had been brought by the industry bodies against the SEC, challenging both 13f-2 and the Securities Lending Rule. It was about 10 months, I think, after the initial hearing of the case. So they kept us waiting, didn't they, Wallace? I think when we'd had discussions, we'd all been hoping to receive the decision at some point over the summer. And so the fact that we got it on our last summer UK bank holiday, I think just about nailed it. They got it in there over the summer. So what did they actually decide? Well, the courts remanded 13f-2 and the Securities Lending Rule in their entirety back to the SEC for consideration of the cumulative economic impact of those rules. And I think beforehand it was quite tricky. We me speaking to Wallace, tried to speculate what the outcome in advance would be. And so I thought ahead of this, it was interesting to look back, because we ran a poll in our January webinar, if you recall, Wallace, to see what our audience thought might be the outcome. And the vote there was overwhelmingly that 13f-2 would be vacated in part just on the non-reporting issuer threshold. So not quite what we'd guessed might be the outcome. But anyway, let's get into the detail and what it actually means now in terms of all of us in preparing to comply with 13f-2. So Wallace, I know that the challenge by the petitioners involved several points. Do you want to just briefly run us through kind of what they were, with particular focus obviously on the point that they actually did win on in the end?
I'd be delighted, Fiona, and thank you very much for having me again. I'm glad. It's a good occasion to bring glad tidings to the assembled in-house counsels and compliance officers on the line. So as Fiona alluded, petitioners brought a bevy of allegations or arguments against these rules. In the main, the court rejected those arguments. I did not to cast aspersions on the petitioner's counsel. They brought the strongest case they possibly could, but they ended up winning just on a single argument at the end. First, the petitioners alleged that the two rules in tandem were arbitrary and capricious, which is the relevant standard under the Administrative Procedure Act in the States, and should be vacated because they were irreconcilably contradictory. Quoting from the opinion, the petitioners argued that the disclosures required by the Securities Lending Rule would reveal the very information that the short sale rule seeks to protect. I think that's an argument that many on the phone here today find telling and persuasive. The court, however, did not. The argument of petitioners here, as you may recall, and this is something also that I put into the amicus brief I filed for a client in this, we argued that the share lending and short selling are two sides of the same coin. You may remember that phrase from previously. As a statistical matter, this is essentially true. I think this is, it's like 98 or 99% of share lending activity has some kind of connection to short selling, if I recall correctly. But it's not a perfectly overlapping Venn diagram. And so the court went with the SEC's argument here that loans are also used to hedge closed positions and obtain collateral. Therefore, the SEC carried its burden to examine the relevant data. So this argument was rejected. Petitioners also brought individually targeted arguments against each rule on its own. And I'll run through these rather quickly, except for one I think it's worth lingering over. For the Securities Lending Rule, petitioners alleged that the SEC had exceeded its statutory authority and that there had been insufficient public comment in the adoption process, largely owing to changes from the proposal to the final rule with respect to, I think, the timing deadlines from 15 minutes to 20 days or whatever, what would have you. The court rejected both of these. The statutory authority argument was, in my view, a bit of a stretch. It was advanced as persuasively as possible by the petitioners. But unlike certain other rulemakings of the previous administration, here we had two Dodd-Frank statutory provisions that specifically called for the rules in question. So I think it was a bit of an uphill battle there. As for the notice and comment issue, this is a very narrow administrative law point. There's a doctrine, some of you lawyers may know, in the states of logical outgrowth. So if the final rule is the logical outgrowth of the proposed rule, you need not have specific notice of every single change or every single amendment made in response to the notice and comment process. In any event, both of those arguments failed. On the short selling rule, you may recall the petitioners argued that the SEC should have considered other less burdensome methods to get the same information. Here, they pointed to the existing FINRA short selling reporting positions rules. The court said the SEC had considered these adequately. Finally, there was an argument, and all of you will know it well, particularly those of you who listened to my turgid explanation of this point back in January, the extraterritoriality issue that's been vexing to a great many of people, both in the private sector legal sphere, but certainly many of you attending today, trying to parse what do we make of the extraterritoriality statements in the final rule release and the SEC's brief, et cetera. The court sort of gave this short shrift, I would say. I don't necessarily agree with the holding of the court here. They said that they accepted the SEC's brief position that the ambit of 13F-2 would be precisely consistent with regulation show and apply only to domestic securities. I don't even think the court quoted the footnote or addressed the footnote about the Morrison decision that I made a lot of hay out of when last we spoke about this in January. In any event, the court went on to, after one after the other, rejecting argument after argument of petitioners, finally the petitioners did win. So the final argument and ultimately the basis of the court's decision was the petitioner's argument that the SEC had failed to consider the cumulative collective economic impact of these two rules. Now, you may recall that these two rules were adopted within 1 hour of each other at the same open meeting. And in the share lending rule, the SEC specifically said, we are under no obligation, and this is what the SEC's brief position was more importantly, we're under no obligation in the share lending rule to consider the effect of the as yet unadopted short selling rule. Mm-hmm. To give you a bit of insight into what this was all about, typically under US law, when adopting a rule, there is an obligation, certainly of the SEC, of doing a cost-benefit analysis. That cost-benefit analysis is measured against the current statutory and regulatory baseline of all existing laws and finalized rules. So it's not commonplace in a rulemaking to consider other proposals that might be floating out there in the ether unfinalized. So far, so good. In the mines run of cases, as the court puts it, that's the perfectly appropriate way to do this as an economic matter. Here, the court described the SEC's attempt to evade doing a cost-benefit analysis of the as yet unfinalized rule, but that we're going to finalize at the same meeting in an hour, as regulatory sleight of hand and as a shortcutting fiction, which is a fairly aggressive way of slapping down a federal regulatory agency by a court. And so to me, this is me rankly speculating about deliberations of the court in which I was not a participant. To me, this opinion reads as an attempt to secure a 3-0 unanimous opinion in a politically split panel where you have an obvious administrative basis to remand the SEC's rulemakings without having to get into or having to decide on the much more complicated and perhaps more politically sensitive questions of rejecting the other aspects of the rule and the merits.
Mm-hmm.
That's my reading of it. Again, take that or leave it. It's rank speculation on my part.
So I guess the next question is kind of what happens now? We've said that it's kind of gets remanded back to the SEC. They've got to do a cost benefit analysis. What does that actually entail on the SEC's part?
Sure. So the actual holding, which I will read, of the case was that the tandem rules had been, quote, insufficiently explained, that the commission had, quote, failed to justify the regulations under the Administrative Procedure Act and the Exchange Act, which is the SEC's organic statute. As such, the court remanded both of the rules to the commission without vacatur to allow the commission to analyze their cumulative economic impact and respond to further comments in view of that analysis. So for the past week, a lot of administrative law eggheads, whom I trust implicitly, have been trying to understand what does it mean to remand without vacation of the rule. In a vacation context, a court can vacate under the APA a rulemaking, meaning it renders it null and void. Okay. Here, the court refrained from doing that. Instead, it remanded to the commission with what I would describe as 2 conditions precedent. One is the SEC must publish a cost-benefit analysis that engages both of the rules simultaneously. And that cost-benefit analysis must be put out for public comment. Okay. As a technical matter, the rules still exist as adopted, but those conditions precedent mean that they're in a state of sort of suspended animation. Now, to anticipate the question that I can imagine all of you are typing in the Q&A thing right now. What does this mean for the January 26th compliance deadline? It's a fair question. I think a good reading of that question is that the January 2026 deadline doesn't apply, subject to the SEC's not issuing that cost-benefit analysis or putting it out for notice and comment. Okay. I don't like giving that as advice, legal advice, because it's confusing. And it's sort of uncertain.
It's a bit murky, isn't it?
It's a bit murky. So talking to some folks, I've spoken to folks in and around the commission. I've spoken to some of my colleagues in the bar here in Washington, and looking at the SEC's past practice in recent past practice with other Chairman Gensler rules that have been invalidated by courts for one reason or another. I would expect, again, speculation on my part, but I think this is more grounded than my prior rank speculation. I would expect that in the coming days, the SEC is likely to put out a statement specifically stating that it does not intend to appeal the decision of the Fifth Circuit, either to the full Fifth Circuit sitting en banc, as we say, or to the Supreme Court of the United States. Okay. I would anticipate that in such a statement, it is likely that the SEC staff or commissioners would make clear that the January 2026 extension is hereby suspended pending further regulatory activity by the commission. Yeah. I have a sense, and many of you have been, I'm sure, talking to your U.S. regulatory counsel or to your trade groups. I think a lot of the trade groups and a lot of lobbyists in DC have been sending a consistent message on this point. I would be somewhat surprised if the SEC did not follow its recent practice and by doing such a statement, but watch this space. It could even happen while we're speaking today, for all I know. Yeah,
so it seems very reminiscent of our January webinar where we were kind of anticipating a sort of an extension statement and constantly checking the SEC website. So I think that it sounds like the message this time is, we're constantly monitoring the SEC's website for a similar announcement, but giving the clarity that the compliance deadline's suspended whilst they carry out this cost benefit analysis.
Yes, and
kind of
Fiona's
get
and
there.
my predictions have come true with a vengeance to date, both on
Yeah,
the
exactly. So I
grounds of
think 2 weeks time,
the
perhaps it should
remand and
be. Yeah,
also on the SEC's statements. So,
yeah,
you can trust our ability to prognosticate, I
exactly.
suppose.
So, given that we will hopefully get that clarification announcements shortly from the SEC, then then that process would then kick in of the cost benefit analysis that you've described, that there is now basically a kind of a CP to them being able to enact the rules. How can our listeners get involved in that process? I think you mentioned it would be a public consultation.
Yes, so this is an interesting point. What the court ordered was a cost benefit analysis that integrates or incorporates the cumulative impact of the two rules. Pure and simple, period.
Yeah.
Now, it didn't say that's all the SEC may do, but it said it must do at least that.
Mm-hmm.
Second, it called for putting that out for notice and comment, by the public. Fair enough. I think we need to account for, and the court doesn't obviously address this, the significant change in political circumstances between when these rules were originally adopted in late 2022 and the present. Mm-hmm. Two of the sitting Republican commissioners, namely Mark Ueda and Hester Peirce, who were formerly the minority when this rule was adopted, are now in the majority, joined by Chairman Paul Atkins. Those two Republican commissioners voiced significant reservations about the proposal and finalization of these rules in the first place. And I don't think we have any reason to believe that they would have changed their minds. Among those concerns were the very ones on which the court decided this case, namely that these were sort of as a legal fiction adopted at the same meeting without considering their mutual effects on one another. I would anticipate, again, I can't predict when this might happen, and I certainly can't speak with any certitude that it will happen the way I say. But it would nevertheless surprise me, given that political context, if the cost-benefit analysis were narrowly cabined to specifically what the court said. I think that this should be viewed as a general reopening of a lot of different issues under the rule. And so if those within the ambit of my voice today have any inclination to comment about any aspect of either rule, whether it be the official list of securities that exists under 13F, but not here,
yeah.
Whether it be the extraterritorial point, whether it be Table 2, or the way in which we figure out, how to deal with over-the-counter securities, all those issues. If those still are burning questions in your mind, this would absolutely be an opportunity to pitch those into the SEC staff. And I think as part of a rational administrative process, I would anticipate that the SEC leadership and staff would be interested in hearing that and might be more receptive than they have been in recent years.
Yeah, I think that's really helpful. So it's kind of dig back in your archives of your initial kind of issues that you had, because I think most of those have not disappeared, and resubmit them if that's the ambit, as you say, is likely of the consultation. And then kind of looking forward, I suppose, how long do these sort of cost benefit analyses tend to take? Because sort of if we have the slight comfort that the compliance of January may be suspended, what data we then look at? I suppose because we've always said a lot all the way along, there's likely to be some kind of short selling provisions. It's mandated under Dodd-Frank statute. So it's not like this legislation is going away. It's being redrafted, and what date will be that kind of compliance date in the future?
So let me start by saying that I have no idea what the length or the date would be. Okay. But let me tell you why I say that, and maybe you could. There's a few items that I think play into the ultimate schedule here. So, as Fiona alluded, the Dodd-Frank Act has these two provisions, 929X and the other, that still are on the books. The SEC is still subject to mandates to issue something like 13F-2 and something like the share lending rule. Now, when these rules were adopted in late 2022, that was already 12 years after the adoption or into signing by President Obama of the Dodd-Frank Act. We are now 3 presidencies later, and we still don't have these rules in effect. So the SEC has not exactly approached this with a great amount of speed and celerity over the years. Second, there's the political issue that I addressed before. Third, many of the people on staff in the Division of Economic and Risk Analysis at the SEC who wrote the original cost-benefit analyses would likely be involved in the rewriting of these cost-benefit analyses to take into account what the court had said. That's a tricky and difficult process for them to reverse or revise the positions they'd staked out in prior rulemakings. Because of the context here of an ongoing or a recently completed federal appellate court decision, I would expect that any cost-benefit analysis that comes out of the Division of Economic and Risk Analysis would then be run by the General Counsel's Office of the SEC and the appellate team involved in this very decision to ensure that whatever that staff of economists comes up with complies with what the court said to do. Now, note also, the court, unlike other cases where we've seen remands and vacations of SEC rulemakings, the court did not impose any deadline here. They didn't say you must do this in a month or 6 months or a year. It's just open-ended. And then finally, whatever comes out of the staff economists, the legal staff of the commission, et cetera, all of that would then have to be run past the 4 or 5 people on the commission who would vote on it, et cetera. And also there'd be interposed between that, there's yet a further step, which is the notice and comment process. And if they decide to do new rules, they'd probably have to put those out for notice and comment as well, and then finalize them. So that's a long process.
Yeah.
That's not weeks, that's months, years, not quick.
Right. So it's one for us to monitor, but it's probably going potentially, hopefully, off of our plate as a headache in the
you will have plenty of notice from aosphere and the press about what happens next here. My anticipation again is this decision, if you really want to boil it down, what the court did here was reject the administrative process that the prior SEC had followed. I think that the SEC, having been burned, is likely to proceed very deliberately. I don't expect we're going to have a 30-day comment period over Christmas and New Year's here. I think we're going to see something like 60 or 90 days, the normal order of major SEC rulemakings. I think they're going to be deliberate, they're going to take their time, and they're going to highlight for the court and all of their observers that we're going to do this the right way. And so I think that's going to take some time.
Okay, I think that's helpful. And then I think just to the last question, which is which you did mention a little bit earlier, foreign securities, because our audience in particular has been grappling with that particular chestnut for quite a while. And I think you mentioned obviously the extraterritorial point was one of the challenges. And then we had the SEC's response saying, well, actually, no, we never meant it to have a broader scope. It's just meant to be securities that are traded within the US. Did we get any extra steer from the court? It sounded like I don't think we did from what you were saying earlier.
I mean, so the court held that the petitioner's argument failed, largely because the court accepted the SEC's position in its brief, as stated. I don't think that this particular issue, at this point, I think from the standpoint of our listeners today, I think this question is moot. The precise procedural posture that surrounded this extraterritoriality issue in the proposal, in the final rule, in the SEC's subsequent statements, are thought that there should be further guidance on this. I think that's all tossed out the window for now. This issue has been brought, if it wasn't obvious to the SEC originally, it certainly should be clear now that this is something that needs to be addressed very clearly in any further rulemaking activity here. I think certainly to the extent you're sending in comment letters to the SEC or making your views known to the commissioners directly in meetings with your lobbyists or trade groups, this is still going to be a live issue. Please, and the ask should be, please give us clarity on this important issue. It's very confusing. We didn't understand how it was going to work out the first time through. I would be surprised if the SEC came back with a series of statements similar to those that have confused us all for the last 2 years in any future rulemaking. But yeah, what the court said rejected the petitioner's arguments, but that's not to say that the SEC can't adopt a different path in the future rulemaking activity it takes here.
Yeah. So I think that's just really helpful, isn't it? In part of the consultation process, we need to just keep hammering on about we don't understand what you want us to do with foreign securities and the threshold B non-reporting issuer kind of point. It's really helpful. So I think that's probably all the main points. So we maybe just look at a couple of the questions that have come in. Which there's one here that's come in that's on the securities lending point, just saying that's been delayed until the 28th of September. Has that been officially confirmed? So I think that's kind of to do, I think probably because we were referring to September, January next year, we were just talking about the short selling piece, not the securities lending.
Right.
I think that's probably where that question has come from, hasn't it? Yeah.
Yeah, I mean, I believe so. I think that has been extended, as I recall. I think that's also in question here, because both rules, as I say, even though the default was held to be in the share lending rule,
yeah,
the remand was of both rules.
Yeah, exactly. There was another question here just saying, what do we think will be the fate of the threshold B, the non-reporting issuer point? I think we've probably kind of covered that, Wallace, but if you want to,
I mean, I can't say for sure what the SEC would decide on this. I think the best leading indicator, and it's not springing to my recollection right now, I think the best leading indicator of what the SEC is likely to do would be to go back and look at the dissents of Commissioners Peirce and Ueda and see what they thought about threshold B, if they addressed it at all. And but other than that, this is really up to it's a new chairman. There's new heads of the divisions of the SEC, and within the broad confines of having to obey what Congress said in its mandates and what the court said, other choices are up to them.
Yeah, no, that makes sense. And then there's another question here to just say, just to confirm that there was no timeline prescribed by the court for taking out the cost benefit analysis by the SEC. Yeah.
Correct. Yes. That this is something that a lot of us did a double take over. It is common for courts to impose deadlines of that type in cases where they remand rulemakings to any agency. They did not choose to do so here. Obviously, given the nature of the rules, if the SEC fails to do the cost-benefit analysis in a timely fashion, it's hard to imagine that the petitioners are going to go into the court and complain, right? So it's an awkward sort of situation. Like I don't think the SEC is simply going to sleep on this forever. There's a court order that says what to do. But as far as when they start it, the only other little piece of evidence that I could adduce to this point, this very morning, the SEC issued what's called its Reg Flex agenda. This is, I think, a semi-annual statement of what the SEC's pipeline of regulatory priorities might be. So it lists what's at the pre-rule stage, things like the consolidated audit trail, what's at the potential proposed rule stage. To my glance this morning, it's heavily involved with questions of capital formation, questions of the regulation of digital assets and cryptocurrencies, and then what final rules are potentially in the offing. Again, don't know how to read into this, but neither the share lending rule nor 13f-2 appeared on that Reg Flex agenda.
So it's not right up their priority list at all then.
Yeah, I don't want to read into silence. I mean, this was going on very much at the same time, and maybe they didn't want to upset the apple cart of the Reg Flex agenda because the court ruled something last week. I don't know. I don't know if there's anything to read into that, but I would suspect, given the fact that the SEC took 12 years to regulate in this area in the first place, I would suspect that given everything else going on at the SEC, the CAT, crypto assets, digital assets, all that, this is likely not to be an area where they want to devote the greatest amount of resources compared to everything else they've got on their plate.
Yeah. And then, Wallace, to wrap up, I think we'll just take one last question there that was just saying, based on kind of what they've heard today, is it advisable now then that firms could just pause all processes that they're putting into place to ensure that they could monitor?
Yeah, I mean, look, I was afraid somebody might pose this question. I'm not going to give legal advice over a webinar about what risk decisions should be taken about suspending that. This is why I hope and expect the SEC will give some guidance on this. I have communicated to friends of mine over there that the private sector is very much focusing on this. 3 months from now, January may feel far from the standpoint of government, but for you in your positions on this phone call, for you, 3 months away is pretty tight. And so I've conveyed, and I know a lot of other practitioners in the market have conveyed to the SEC that, look, we would like to see something concrete to sink our teeth into, so that I can tell the anonymous attendee, yes, you're off the hook. But I'm not going to say, you're not going to hear those words out of my mouth until I see something from the SEC.
Understood. Thanks, Wallace. So I think that's great, and we've literally managed to do all of that in just over half an hour. So I think if we just wrap up there, Wallace, thank you so much. I think that's been really helpful of kind of unpacking kind of the court decision and sort of the what's potentially next from the SEC. And as we've said in the webinar, aosphere, and also with the assistance of Wallace, will be continuing to monitor for developments, including hopefully that helpful statement that should come out of the SEC, so that we can know a bit more timing wise what's going on. So thank you all for joining us today.
And thank you. And thanks to aosphere for getting the word out.
Thank you, Wallace.
Bye.